Right, this is the motion that I submitted a couple of days ago to West Milwaukee. Me versus them. They're the plaintiff, though. In the municipal court of the village in the state of Wisconsin, I have two case numbers. This is the motion, actually. Motion for just leave it like it is. Motion for new trial and transfer to Milwaukee County Circuit Court. Defendant Travis Hines, appearing pro se, hereby moves the court for an order granting a new trial in Milwaukee County Circuit Court based on procedural errors, judicial misconduct, and due process violations that occurred during his trial in the West Milwaukee Municipal Court. In support of this motion, Mr. Hines states as follows: denial of rights to legal representation. Mr. Hines was denied his fundamental right to legal counsel during the municipal court proceedings, despite facing quasi-criminal allegations and the possibility of punitive sanctions, including incarceration upon non-payment of fines. He was not provided a court-appointed attorney or the opportunity for a free lawyer. Both the Sixth Amendment of the United States Constitution and Article 1, Section 7 of the Wisconsin Constitution guarantee the assistance of counsel in criminal prosecutions. And these really should not be there. The U.S. Supreme Court has held that the accused cannot be subjected to actual imprisonment unless provided with counsel. By denying Mr. Hines any legal representation when he could not afford an attorney, the municipal court violated these constitutional safeguards. This denial is especially egregious given that the city was represented by a prosecutor, creating an imbalance where Mr. Hines had to defend himself pro se against a trained attorney. The lack of counsel undermined the fairness of the proceeding and warrants a new trial. The right to counsel attaches to any proceeding that may result in incarceration. Even if the charge... Let's see, where was I? Even if the charge was styled as a civil ordinance violation, it was quasi-criminal in nature. Under our Judicial and its progeny, no person may be imprisoned for any offense, petty or otherwise, unless he was represented by counsel or made a valid waiver. Wisconsin courts likewise recognize the importance of counsel in ensuring a fair trial. Because Mr. Hines was forced to proceed without counsel and did not knowingly waive that right, any judgment against him cannot stand. A new trial in circuit court with the opportunity for counsel, appointed if necessary due to indigence, is required to cure this defect. Failure to sequester a key witness, Chief Jamie Aide. The municipal court refused to sequester Chief Jamie Aide, a key prosecution witness, during the trial. Even though Mr. Hines requested witness sequestration, Chief Aide was allowed to remain in the courtroom and hear the testimony of other witnesses before he took the stand. This violated standard procedure and undermined the truth-finding process. Wisconsin Law 906-15 provides that at the request of a party, the court shall order witnesses excluded, so they cannot hear others' testimony. The purpose of sequestration is to prevent a witness from tailoring his testimony to match what other witnesses have said. Here, by hearing the prior testimony, Chief Aide had the opportunity, consciously or not, to adjust his story to bolster the prosecution's case. This creates a serious concern that his testimony was not wholly independent or truthful. Failing to sequester a witness upon request is an error of law and an abuse of discretion. Wisconsin's evidence rules explicitly authorize judges to separate witnesses and forbid them from discussing testimony with others. Courts have recognized that when a witness hears another's testimony, the second witness might then tailor his or her testimony to that of the first witness, potentially frustrating the fact finder's ability to discern the truth. Preventing such witness coaching is fundamental to a fair trial. By allowing Chief Aide to remain in court and subsequently testify, essentially as an informed witness, the municipal court compromised the integrity of the trial. This procedural error prejudiced Mr. Hines' defense and is grounds for a new trial in circuit court where proper witness sequestration can be enforced. During the municipal trial, the judge exhibited clear bias in evidentiary rulings, consistently favoring the prosecution over the defense. Mr. Hines' objections were routinely overruled, while the prosecution's objections, often of a similar nature, were consistently sustained. Legitimate points raised by Mr. Hines, for example, objections to hearsay or to leading questions by the prosecutor, were dismissed without fair consideration. In contrast, when Mr. Hines attempted to introduce evidence or question witnesses, the judge frequently intervened to limit his presentation. This one-sided application of the rules of evidence denied Mr. Hines the impartial tribunal that due process requires. A cornerstone of due process is the right to a neutral, unbiased judge. Even the appearance of judicial bias can necessitate a new trial. The U.S. Supreme Court has held that under the Due Process Clause, objective standards that do not require proof of actual bias are applied to ensure fairness. In other words, due process may sometimes bar trial by judges who have no actual bias and who would do their very best to weigh the scales of justice equally. When circumstances create a serious risk of bias, here the judge's selective rulings and hostile conduct toward Mr. Hines demonstrate an objective risk of bias. Wisconsin courts similarly hold that a defendant's right to a fair trial is violated if the judge's conduct or rulings create the appearance that the judge is not impartial. The record in this case shows a pattern of rulings against Mr. Hines that is so one-sided as to undermine confidence in the verdict. Judicial misconduct or bias of this nature voids the judgment and warrants a de novo trial before a different court. Mr. Hines is entitled to have a neutral judge apply the evidentiary rules even-handedly to both sides. Mr. Hines attempted to introduce video evidence that was crucial to his defense and exculpatory in nature, but the municipal court improperly barred this evidence from being presented to the fact finder. The prosecution, meanwhile, was permitted to show selectively edited video clips that supported its version of events. When Mr. Hines sought to play portions of the same videos or other recordings that would provide context or demonstrate his innocence, the court sustained the prosecutor's objections and prevented the jury or judge from seeing that evidence. This selective exclusion of defense evidence violated Mr. Hines' constitutional right to present a complete defense. A defendant's right to present exculpatory evidence is a fundamental aspect of a fair trial. The U.S. Supreme Court in Chambers v. Mississippi held that a state may not apply its rules of evidence in a way that prevents a defendant from presenting reliable exculpatory evidence because that denies the defendant a fair trial. By refusing to admit Mr. Hines' video evidence, which was directly relevant and could show his conduct or the incident in question in a different light, the municipal court effectively denied him a fair opportunity to defend against the accusations. This error is compounded by the fact that the prosecution was allowed to cherry-pick segments of video to use against Mr. Hines, while Mr. Hines could not show portions favorable to him. Such an imbalance violates due process and the principle that all relevant evidence should be weighed. Furthermore, Wisconsin's rule of completeness provides that when one party introduces part of a recorded statement or video, the opposing party may require the introduction of any other part, which ought, in fairness, to be considered contemporaneously. This rule is meant to prevent misleading impressions and ensure the jury gets the full context. Here, fairness required allowing Mr. Hines to play the remainder of the video or other related footage to contextualize or rebut the prosecution's clips. The judge's refusal to allow this violated Wisconsin Statute 901.07's intent and Mr. Hines' broader right to present evidence in his favor. Because this evidentiary ruling likely affected the outcome, the fact finder did not see evidence of Mr. Hines' innocence or mitigating circumstances. A new trial is necessary where all relevant video evidence can be presented and evaluated. The municipal judge unduly limited Mr. Hines' cross-examination of the prosecution's witnesses, imposing arbitrary restrictions that hampered his ability to challenge the city's case. Cross-examination is the primary means by which a defendant can test the credibility and reliability of prosecution witnesses. In Mr. Hines' trial, the judge curtailed this right by interrupting Mr. Hines' questioning, disallowing reasonable lines of inquiry, and at times setting time limits or topic limits without justification. For example, when Mr. Hines tried to question a witness about inconsistencies in their statements or potential bias, matters directly relevant to the witness's credibility, the court cut off the inquiry or sustained the prosecutor's objections for reasons that were not applied when the roles were reversed. These actions gutted Mr. Hines' ability to make his defense through effective cross-examination. The right of an accused to confront and cross-examine witnesses is guaranteed by the Sixth Amendment and the Article 1, Section 7 of the Wisconsin Constitution. The right to meet the witness face to face. The U.S. Supreme Court has emphasized that the main and essential purpose of confrontation is to secure for the opponent the opportunity of cross-examination. Unduly restricting a defendant's cross-examination violates the Confrontation Clause, especially when the restrictions impede the defendant's ability to expose a witness's bias or inconsistency. In Davis, the Supreme Court reversed a conviction where the trial court prevented inquiry into a witness's possible motive to lie, underscoring that the defendant's right to effective cross-exam outweighs other considerations. Likewise, Wisconsin courts have long held that broad cross-examination is vital to a fair trial. An accused should be allowed to cross-examine to discover why an accomplice has pleaded guilty and has testified against him. This principle illustrates that exploring witness bias, motives, or inconsistencies is an essential part of the defense. In Mr. Hines' case, the arbitrary limits on cross-exam prevented him from fully impeaching the witnesses against him or revealing the whole truth. This was a structural error impacting his right to confront his accusers. A new trial must be granted so that Mr. Hines can exercise his full cross-examination rights. In the circuit court trial, the judge should ensure that Mr. Hines or his counsel is given wide latitude to question the city's witnesses, subject only to the normal rules of evidence and without the prior judge's bias or interference. After the municipal court verdict, Mr. Hines sought to appeal the decision to the Milwaukee County Circuit Court. The municipal judge, however, failed to clearly explain the appeal procedures and fees on the record. There was no mention in open court of the specific appeal filing fee, transcript fee, or appeal bond required. This omission created significant confusion and posed a barrier to Mr. Hines' exercise of his right to appeal. As pro se defendant and one of limited financial means, Mr. Hines was left uncertain about how to perfect his appeal. Only later did it become apparent that an appeal, bond, or fee was expected, by which time procedural deadlines were looming or past. The lack of guidance effectively put Mr. Hines' appellate rights in jeopardy through no fault of his own. Wisconsin law provides a mechanism for appealing municipal court judgments. Wisconsin Statute 800.14.1 requires a defendant to file a written notice of appeal within 20 days of the judgment. Additionally, the state statute allows the municipal judge to require the defendant to post an appeal bond, often equal to the fine or a portion thereof at the judge's discretion. In Mr. Hines' case, if such a bond or fee was required, the judge did not inform him on the record, nor ensure he understood what needed to be done. By failing to announce the amount of any appeal bond or the necessity of paying an appeal fee, the court denied Mr. Hines fair notice of the steps to secure his appeal. This is a procedural error that threatens to deprive Mr. Hines of his right to a review in circuit courts. It is a fundamental principle of due process that a litigant, especially one acting without a lawyer, must be notified of critical procedural requirements. When the state provides a right to appeal, it cannot impose traps or hurdles that unfairly prevent a defendant from invoking that right. The U.S. Supreme Court in Griffin v. Illinois famously stated, "There can be no equal justice where the kind of trial a man gets depends on the amount of money he has." In Griffin, the court held that states must ensure indigent defendants have equal access to appeals, in that case by providing trial transcripts without cost. The same logic applies here. If Mr. Hines' attempt to appeal was impeded by an unspecified fee or bond, then the process effectively discriminated against him due to his lack of funds or legal knowledge. Conditioning an appeal on the payment of money without clear notice or consideration of indigency violates equal protection and due process. Wisconsin courts have likewise recognized that indigent defendants should not be denied appellate review due to inability to pay fees or bonds. The municipal court's silence or ambiguity regarding the appeal fee is tantamount to a due process violation. As relief, Mr. Hines asked the circuit court to excuse any missed procedural steps that occurred as a result of the municipal court's failure to inform him. The court should waive any appeal bond or fees or deem them satisfied so that Mr. Hines' appeal can proceed on the merits. Additionally, this irregularity in itself is grounds for a new trial. The confusion around the appeal process is part of the denial of Mr. Hines' right to a fair adjudication. To ensure Mr. Hines is not punished for the municipal court's omissions, this court should grant a new trial in the circuit court and allow it to go forward without financial barriers. Notably, Mr. Hines is prepared to proceed in forma pauperis if necessary and to comply with all the appellate procedures now that he is aware of them. He simply asked for the opportunity that he was nearly denied due to the lower court's error. In light of all the above issues and to secure the fairest possible retrial, Mr. Hines respectfully requests a trial by jury in the Milwaukee County Circuit Court. The initial municipal court trial was a bench trial, as jury trials are not available in municipal court, and it resulted in numerous irregularities. A jury trial will provide an additional safeguard of impartiality by allowing 12 citizens, or the statutory number for such cases, to hear the evidence and render a verdict, rather than a single municipal judge whose neutrality has been called into question. Given the quasi-criminal nature of the case and the potential consequences for Mr. Hines, a jury trial is the most appropriate forum for the retrial. While the Wisconsin Constitution guarantees the right to a jury trial in criminal prosecutions, that right is typically not extended to municipal ordinance cases at the municipal court level. However, Wisconsin law does provide for jury trials upon appeal to circuit court in certain situations. For example, Wisconsin Statute 800 permits a defendant charged with a first offense OWI, a municipal ordinance violation, to demand a jury trial within 10 days of the initial plea, thereby transferring the case to circuit court for a jury. This reflects a legislative policy that defendants should have access to jury trials for serious ordinance violations once in circuit court. Likewise, Wisconsin case law demonstrates that defendants who appeal municipal convictions can obtain jury trials in circuit court. In City Racine v. Robinson, for instance, a defendant convicted of a municipal trespassing ordinance appealed, and the circuit court scheduled a jury trial at his request. Mr. Hines seeks the same opportunity here. Fundamentally, a jury trial is warranted in the interest of justice. The issues in Mr. Hines' case, which involve credibility determinations, disputes over evidence, and allegations of official misconduct, are the types of issues best resolved by a panel of impartial jurors. A jury would ensure that the community's conscience is brought to bear and that the outcome is not tainted by any one individual's bias. Given that the municipal court process has been marred by irregularities, a jury trial in circuit court will help restore confidence that the verdict is fair and based on evidence, not on improper procedure or bias. Mr. Hines is prepared to post any required jury fee or comply with necessary procedures to secure a jury, but he praised the court to facilitate this request in light of the earlier confusion about fees. Ultimately, providing a jury trial will help guarantee Mr. Hines' constitutional rights to a fair trial as fully realized in his appeal. For all the foregoing reasons, Mr. Hines respectfully asks this court to grant a new trial in Milwaukee County Circuit Court on the charges against him with the following specific relief: vacate the municipal court judgment, reverse or vacate the conviction and judgment entered by the West Milwaukee Municipal Court due to the numerous errors and due process violations that occurred in those proceedings. Immediate transfer and scheduling. Transfer jurisdiction of this matter to the Milwaukee County Circuit Court, if not already on appeal, and schedule the case for a trial de novo. Mr. Hines requests that this new trial be before a jury of his peers, pursuant to his demand for a jury trial as stated above. Right to counsel on retrial. Ensure that Mr. Hines is informed of his right to counsel for the new trial. If an incarceration is a possible penalty or if the court otherwise deems it appropriate, Mr. Hines asks that standby counsel or appointed counsel be made available given his indigent status, so that he does not again face the prosecution alone. At minimum, Mr. Hines should be allowed a sufficient time and an opportunity to obtain counsel or other legal assistance before the new trial. Admission of evidence and fair procedure. Order that the new trial be conducted under fair procedures, including proper sequestration of witnesses on request, impartial evidentiary rulings by the trial judge, allowance of all relevant exculpatory evidence such as the full video recordings to be presented by the defense, and full cross-examination rights for both sides. The court should admonish that the errors identified in the municipal trial must not be repeated. No financial bearers. Waiving any appeal, bond, jury fee, or other fee that would prevent this case from being heard afresh. Given that the municipal court did not clearly impose or explain an appeal bond in open court, Mr. Hines asked the circuit court to either treat the appeal bond requirement as waived or allow him to sign a personal recognizance bond. The goal is to ensure that lack of money does not block Mr. Hines' access to a fair trial. And if any fees, such as a jury fee, are necessary, Mr. Hines will comply, but he requests that the court's guidance and, if appropriate, considerations of his indigency for possible waiver. Mr. Hines believes that the interests of justice strongly favor granting a new trial under these conditions. The record from the municipal court shows that he did not receive a fair or impartial hearing. By ordering a trial de novo in circuit court with the safeguards described, this court will be upholding Mr. Hines' constitutional rights and the integrity of the judicial process. No party will be prejudiced by a new trial. The city will have the opportunity to present its case to a jury. and then Mr. Hines will finally have the chance to defend himself on a level playing field. Given the procedural history, a jury's verdict in a properly conducted trial will carry a greater legitimacy and finality. Wherefore, the defendant appellant, Travis Hines, respectfully requests that this motion be granted in its entirety and that the court enters in an order for a new trial in Milwaukee County Circuit Court before a jury and for such other and further relief as may be just and proper. Mr. Hines additionally requests an expedited hearing on this motion if necessary so that his appeal is not unduly delayed and justice is not further deferred.